The Juvenile Justice and Welfare Act of 2006, also known as Republic Act Number 9344. RA 9344 promotes the creation of a child-friendly justice system focused on rehabilitation and restoration rather than punishment. Before RA 9344 was enacted, children at risk and children in conflict with the law were treated much like adult offenders. Fortunately, this law intends to deal with these children without resorting to judicial proceedings. Instead of punishing juvenile offenders and treating them as criminals, these child offenders will be provided by the state and the community with assistance to prevent them from committing future offenses. What are some of the highlights of RA 9344? Some of which includes prohibiting the detention of children in jails, raising the age of criminal responsibility from 9 years of age to 15. It strengthens rehabilitation, reintegration, and aftercare programs, and introduces community-based diversion programs for children who commit non-serious offenses. What is restorative justice? Restorative justice is a principle which requires a process of resolving conflicts with the maximum involvement of the victim, offender, and the community. It primarily aims to achieve reparation for the victim, reconciliation of the offender, the offended, and the community, and enhancement of public safety. It also ensures that the child's rights will not be infringed when he or she admits to the offense. The main features of RA number 9344 are the diversion and intervention programs. So what is an intervention program? During the intervention programs, they will undergo a series of activities to address issues that cause them to commit an offense. These activities may take the form of counseling, skills training, and education.
To continue with the discussion, again, the main features of RA 9344 are the diversion and intervention programs. So what is diversion? Diversion refers to an alternative process in determining the responsibility and treatment of children in conflict with the law without resorting to formal court proceedings. Its mechanisms include conferencing, mediation, and counseling. The diversion program should include adequate social, cultural, and psychological responses and services for the child. Diversion programs may be agreed upon, but are limited to restitution of property, reparation of the damage caused, indemnification for consequential damages, anger management, and values formation. So we ask then, why should children at risk and children in conflict with the law be kept out of the formal criminal justice system? Several years of experience shows that the process of going through the formal criminal justice system can be harmful to children in many ways and can make them likely to remain criminals. To protect their physical and psychological well-being and their development to the maximum extent possible, the cases should be diverted away from the criminal justice system and to alternatives that benefit the child's family, and the society in a better way. Another question is, does RA 9344 embolden children to commit more crimes? The answer is no. Contrary to the belief that it encourages crime, RA 9344 in fact institutionalized a systematic approach to prevent children from being in conflict with the law. We also ask, what will happen to children in conflict with the law who commit heinous crimes such as rape or murder? The treatment given to the children in conflict with the law depends first on the age, second on the act of discernment, and third on the penalty imposed on the offense committed. If the children in conflict with the law are 15 years of age or above 15 but below 18 years old at the time of the commission of the offense and found to have acted without discernment, the child is exempt from criminal responsibility regardless of the nature of the crime committed. However, if the child is above 15 but below 18 who acted with discernment, committed an offense with an imposable penalty of more than 6 years imprisonment, as in cases of rape or murder, the law provides that the child shall undergo court proceedings. When brought to the court, the child may be placed under suspended sentence and be subjected to rehabilitation programs. The child in conflict with the law may even be confined by court order in a facility for minors, where children are made aware that inappropriate behavior on their part cannot go unpunished and that they must account for wrongful acts.
Should we lower the age of criminal responsibility to 12 years old? No. The Juvenile Justice and Welfare Act is a child protection measure Children in conflict with the law and children at risk are victims of circumstances beyond their control. They are victims of abuse, of dysfunctional families, and insensitive communities. They should be treated as individuals with the problems who need help and need to be provided with appropriate assistance and services to ensure the full protection of their rights for survival, protection, and development and participation. At this age, children are not yet emotionally stable and their social judgment has not yet matured. Where will victims or parties aggrieved by children in conflict with the law seek justice? According to the law, under Rules 30 and 34, any person contesting the age of the child in conflict with the law prior to the filing of information in any appropriate court and the assessment of absence of discernment may file the appropriate case before the family court and prosecutor respectively. Other laws that protect the rights of the victims, such as RA 7610 or the Special Protection of Children Against Abuse, Exploitation, and Discrimination Act, RA 9208, or the Anti-Trafficking of Persons Act of 2003, RA 9262, or the Anti-Violence Against Women and Children Act of 2004. With the advent of the internet and other means of communication, can children really not know the difference between what is wrong and what is right? Where is the evidence that tells us that children under age of 18 cannot properly judge the implication of their action? Mere access to information does not equal discernment, wisdom, or maturity. The Philippine legislature, based on its decision to establish minimum age of criminal responsibility at over 15 years old, from medical and psychosocial research conducted on Filipino children. At age 15 and below, children's brains have not physiologically matured. Studies in the past have also shown that 15 years old is within the stage of adolescence, the transition age, which is being characterized by curiosity, tryouts, and identity crisis. These circumstances expose them to risky and delinquent behavior. At this age, children are not yet emotionally stable and their social judgment has not yet matured. What if the local government cannot afford to put up a facility and rehabilitation program? If the law is given a chance to work, the coordination among concerned government agencies and local government can bring. For example, the DILG could look into LGU compliance and ensure that 1% of the internal revenue allotment supports the implementation of RA 9344. Also, community members have a role to play in ensuring that children are looked after. Children are everyone's responsibility, and it is not only up to the government to provide this intervention. The private sector, parents, etc. also have the role to play.
All records and proceedings involving children in conflict with the law, from initial contact until final disposition of the case, shall be considered privileged and confidential. The objective of rehabilitation and reintegration of children in conflict with the law is to provide them with the interventions, approaches, and strategies that will enable them to improve their social functioning with the end goal of reintegration to their families and as productive members of their communities. The following are community-based programs which shall include, but not limited to, competency and life skills development, socio-cultural and recreational activities, community volunteer projects, leadership training, social services, home life services, health services, spiritual enrichment, and community and family welfare services. The Youth Rehabilitation Center shall provide 24-hour group care, treatment, and rehabilitation services under the guidance of a trained staff, where residents are cared for under a structured therapeutic environment with the end view of reintegrating them in their families and communities as socially functioning individuals. The objectives of community-based programs are to prevent disruption in the education or means of livelihood of the child in conflict with the law, to prevent separation of the child in conflict with the law from his or her parents or guardians, to facilitate the rehabilitation and mainstreaming of the child in conflict with the law and encourage community support and involvement, and lastly, to minimize the stigma that attaches to the child in conflict with the law by preventing jail detention. The following are prohibited acts: employment of threats of whatever kind in nature, employment of abusive, coercive, and punitive measures, employment of degrading, inhuman, and cruel forms of punishments, and lastly, compelling the child to perform involuntary servitude in any and all forms under any and all instances. Penalties: any person who violates any provision of this act shall be punished by a fine of not less than 20,000 pesos, but not more than 50,000 pesos, or suffer imprisonment of not less than 8 years but not more than 10 years, or both. Such fine and imprisonment at the discretion of the court unless a higher penalty is provided for in the revised penal code or special laws. If the offender is a public officer or employee, he or she shall, in addition to such fine and imprisonment, be held administratively liable and shall suffer the penalty of perpetual absolute disqualification.